We had a Private Privacy Act passed in the early 90s. There have been some recent amendments which make Quebec privacy law some of the strictest in the world, bringing it closer in line with Europe's GDPR. So Quebec, in my view, tends to represent the high watermark of Canadian privacy law, such that if your client seeks a review of Canadian privacy law across all jurisdictions, it's of course optimal to do an analysis of all legislation, but you can also sometimes take the position, and I repeat, sometimes take the position, that by doing a Quebec analysis, you should be compliant with most of the other laws just by virtue of the fact that Quebec law is stricter. But again, you need to be very careful about that. Quebec's law, per recent changes, implements new enforcement mechanisms, and these are really tough enforcement mechanisms. You have AMPs, or administrative monetary penalties, which lead to, and those penalties could be $10 million or 2% of annual turnover for an offense. Penal offenses, up to $25 million or 4% of annual turnover. Punitive damages. So all that said, compliance, super important to not run into these enforcement mechanisms. When does Quebec privacy legislation apply? Well, in short, it applies to a person collecting, holding, using, or communicating to third persons personal information while carrying on an enterprise. Personal information is any information which relates to a natural person, directly or indirectly, and allows that person to be identified. And an enterprise is really just an organized economic activity. There's a set definition in the Civil Code of Quebec. Now, there's some new and interesting rules as well. We're, again, really going high level and non-exhaustive. The new rules require companies to appoint a privacy officer. They include rules regarding transfers of personal information outside of Quebec, requiring what is called a privacy impact assessment. So if you have a Quebec branch office sending Quebecers' personal information to a New York head office, that will require what is called a privacy impact assessment, and it's advisable that you do a fulsome analysis of other ways that the Privacy Act might apply. Automated decision-making. When organizations make a decision about someone based exclusively on automated processing of their PI, for example, recruiting, there are a whole host of rules to comply with. And there is also a right to restrict dissemination of personal information and to de-index personal information. Now, this is a little narrower than the right to be forgotten under the GDPR, but again, it's still quite an important rule or set of rules, and represents definitely Quebec privacy law becoming more onerous.